This session is entitled Protecting Children in Family Court Cases. For this conversation, we bring together a seasoned journalist, 3 courageous survivors turned activists, and an active family court judge to discuss some serious systemic issues that have led to tragic outcomes. The panel will also share their thoughts on how to make family courts safer for children. This session comes with a trigger warning, as the survivor stories tragically demonstrate why there needs to be systemic reform. The moderator for today's conversation is Jane O'Donnell. Jane is founder and CEO of Youthcast Media Group and USA Today's former health policy reporter. Youthcast Media Group trains diverse high school students from under-resourced communities to do multimedia health and social issue journalism and gets their work published in media outlets. While at USA Today, Jane covered many beats, including health policy, mental health, childhood trauma, and patient safety. As an author, TV, and radio contributor, Jane has appeared on Good Morning America, CBS This Morning, CNN, MSNBC, NPR, and C-SPAN, and has been published in many notable magazines.
It's conservatively estimated by the Leadership Council that 58,000 children are court-ordered into unsupervised visitation with unsafe parents, both mothers and fathers. Allegations of abuse and concerns of child safety are met with suspicion, and pleas for safeguards and protection are often denied by family court professionals. Children and the parents trying to protect them often spend years involved, immersed, surrounded by abuse, trauma, and toxic stress. And these are the cases where the parents are actually lucky, because hundreds of children have been killed in this context. Professionals and survivors will discuss roadblocks to child safety and how they envision a family court system that better protects children. First, I'm going to introduce Judge Tracy Vandenberg. Judge Vandenberg was elected by the, by the voters, of Washtenaw County, Michigan in 2020, and took the bench in January 1st, 2021. Before practicing law, Judge Vandenberg first earned her bachelor's and then her master's degree in social work from NYU. As a clinical social worker and mental health director, she diagnosed and treated children, adults, and families struggling with substance abuse and mental health issues. Motivated to address related issues, she subsequently earned her Juris Doctorate from from Michigan State College of Law, and she graduated in the top 5% of her class. Thank you for joining us, Judge. Annie Kenny.
Thank you so much for having me.
I'm so excited to meet you. Annie Kenny is with us from Maryland. She's a certified high conflict divorce coach and victim advocate. Her organization, Bloom Consulting, is dedicated to helping protective parents with their own personal family court battles, as well as promoting family court legislative reform. She's a member of her local Family Violence Coordinating Council and has served as a panelist on the Allen versus Farrow panel series. Her personal story has been featured by WJLA, and her op-ed about her family court journey, which you'll hear more about, which is shocking, was published by the Washington Post. Annie, thank you so much for being with us. Anna Estevez. She was honored as the 2019 California Woman of the Year. She's a U.S. Army veteran and a Los Angeles County educator, has been a Los Angeles County educator for 25 years. Most importantly, however, she was Peaky's mom. She's a passionate keynote speaker who spreads awareness regarding child safety, filicide, and the need for systemic changes in family court and child protective services. Her son, Peaky, am I pronouncing it correctly, Anna? Peaky, I'm sorry. Peaky died how many years ago? 5?
It's been 5.5 years.
5.5 years ago. The system rejected her many pleas for intervention, including her final one when she begged the court for supervised visitation just 1 week before her son's murder. Thank you for being here, Anna. Lee Block it's been longer for her, but no less painful. She was a protective parent and survivor of domestic violence. Tragically, her 5-year-old daughter, Michaela, was not. Leah's ex-husband, John Tester, murdered Michaela and then took his own life during an unsupervised visit over Labor Day weekend in 2004. Her ultimate goal is to make the health and safety of children a priority in family court cases with the help of legislators in Minnesota. She wants to prevent other families from going through what she and her daughter, Michaela, endured. Thank you so much for being here, Leah. Let's do a quick round robin. If everybody could say one word that describes their experience in family court, and then take 2 minutes and no more than 2 minutes. I might even interrupt to describe what your story, describe your story as best you can. There'll be plenty of other times to talk about them. Let's start with you, Leah.
One word to describe family court. Hell. My husband at the time, and he became abusive actually after Michaela was born in 1998. And probably 3 years later, I called 911 for the very first time. And that is when law enforcement got involved. Before that, I pretty much kept everything that was going on under our roof. And finally, he served me divorce papers, which I was really happy about. But that is when things got even worse, because through family court, they want to determine custody. And I was the main caregiver. And although he was abusive shortly after her birth, it didn't matter in family court. I was not believed. And I thought that I would be supported. And I was not. I was pretty much on my own. So that's why I'm here today.
Thank you so much, Lee. Annie?
So I would use the word disorienting for my family court experience. There seemed to be such a disconnect from reality, and it's almost like an alternate set of rules where everything that's being talked about isn't what's important, and no one's talking about the safety of the children. I mean, it's almost like designed to make you feel bad for pursuing what you're trying to do, or they paint you to be angry or vindictive or anything other than just scared for the safety of your children. Now, the brief synopsis of my case is that my ex-husband was convicted of abusing my oldest daughter, and he is now a Tier 3 registered sex offender for life. That occurred before I ever stepped foot in family court, but I still spent 4 years trying to keep my younger 2 daughters protected from him.
Just unbelievable. Anna Estevez?
The one word that I would choose to describe my experience in family court would be devastating. I have many, but that would probably be at the top of my list. A quick summary of my case. In April of 2016, I told my ex-husband that I wanted a divorce. And from the day that I walked into the courtroom, I wholeheartedly believe that the judge who presided on my case at first glance had it out for me. Over the course of 1 year, family court failed both my son and me repeatedly. My ex-husband committed perjury every time he submitted a declaration to the court. He wrote lie after lie, and somehow the judge always believed him. He was able to obtain exclusive rights to our family home and everything in it. He was awarded spousal support and child support based on lies. He filed false allegations with Child Protective Services, and as a result, my son was forced to undergo a forensic medical exam. Of course, there were no findings. He was interviewed by a forensic psychologist who, in her report, wrote that she believed my son was being coached. My son was interviewed by a mental health consultant who asked him if he was afraid of his father, and his response was, "I don't want to talk about that." This, along with a plethora of other evidence, was introduced during my second restraining order hearing, and the judge ignored the evidence. During that second hearing, I had subpoenaed 3 law enforcement officers from different agencies who were there to testify on the abuse, and the judge denied all 3 officers from testifying, saying that they were there for custody reasons, not abuse. At the end of that restraining order hearing, the judge flat out told me that my ex-husband, who is a murderer, that his testimony was more credible than mine. During that year that we went through our divorce, my ex-husband terrorized our son emotionally and began to abuse him physically. He succeeded in convincing the court evaluator to change our custody agreement. And 8 days after that, he murdered our son. When he failed to show up for a child exchange, I filed a missing child report. At the time, I did not know that my son had been murdered. My son was missing for 2 months. And during that time, I went back to court to request sole custody, both legal and physical, which was denied. The judge, even though my son went missing while in the custody of his father, he denied my request and ordered an evidentiary hearing instead. And I continued to pay spousal support and child support until July 2017, long after my son had been murdered. I returned back to court 2 years after to fight for my pension, my retirement, because he was awarded that in our divorce as well. You're on mute, Jane.
Judge, I really wasn't going to insist that you use a word to describe the system that you work in, but you're perfectly welcome to. But I wondered if you could just touch on, how your experience as a social worker over all those years made you want to pursue family court. What did you see?
Well, let me step back, because I am more than willing to talk about the system that I work in. This is what I'll say. I'm happy because that's why I'm here, and I'm a very direct person. As a lawyer and an advocate, the whole reason I ran for my current position is because, maybe this doesn't do it justice, but I found family court disappointing and infuriating and frustrating. That's 3 words I'm now way over. As a family court judge, I find family court many times heartbreaking. So it was through that lens of wanting to change things in family court that I ran for this position. So I'm, and there are a lot of hurdles to doing that, but I'm happy to answer your other question, but I'm happy to also participate as everybody else. So.
Okay, well, we can, why don't we just stick with you for a minute though? You do incorporate the survivors' lived experiences in your decision making, and you're a supporter of Family Court Awareness Month. Critics might say that might not, it's a double negative, but you might not be impartial because of that. What would you say to people that suggest that?
There is nothing in the judicial canons or the judicial rules of ethics that says we have to be impartial about child abuse or domestic violence. Simply, I mean, that's it. That's it. When I think about Lee and Michaela, of course, because there are real consequences to my decisions. And, probably if I stay in this job long enough, I'm probably not going to get it right at some point. Based on, you just never know. You do your best, but There is nothing about being against domestic violence or protecting children from child abuse. And domestic violence is child abuse against children, in addition to all the other forms of abuse we could talk about. That is bias. I mean, yes, it's a bias, but it's an appropriate bias. And I think that when judges say I have to be impartial and fair and unbiased, that negates, I mean, it's just not true from the standpoint of every time we make a decision at the point that Anna suffered, from these poor decisions made by a judge that resulted in the murder of her child. That judge made a decision based on evidence. I'm not saying it was good evidence, but when you make a decision for one side, you have a bias. You have, you weighed the evidence for one side more than the other. That's how we make decisions. So I think that whole concept of, as I said, you have to be neutral about domestic violence or child's abuse is just incorrect.
Mhm.
And I think we have to weigh the evidence, but absolutely, if it's going on, we have to take the appropriate steps to protect the family and the children.
Mhm.
That's our job.
Right. Thank you so much. In our conversation before the official call, something you said really jumped out at me that I'd heard when I've done research on this in the past about how family court is kind of a last choice or among family court judges. But then you have such an incredible background, it would seem, to be a family court judge. Meanwhile, there have been efforts in several states to require training to bring the knowledge and understanding of child trauma up to a level perhaps approaching yours, but they failed in some cases. Annie Kenny, I know you were involved in what happened in Maryland, and you have your personal reason for doing it. But could you talk a little bit about that, just as a mother who went through the family court system, how you feel about the fact that these judges don't even want to take these cases, that it's considered the bad job to decide the future of your children?
I think there's so much open for interpretation that's one of the reasons that maybe judges don't necessarily like this particular arena. It's harder for them to see maybe what is the black versus the white, where is this line, what is actually happening, where in maybe other types of cases, there's a more definitive law to be following. And then that's it. But here there's so much room for interpretation. What's even more so is it seems like people get personally triggered, but in ways that maybe aren't appropriate. They'll take some sort of piece of information and they'll want to just view it as not credible, but they don't really have a reason for thinking it's not credible other than maybe they don't like the way that you said it, or maybe you rubbed them the wrong way with how you were dressed today, or maybe you're being too aggressive because you're panicked and you're trying to protect your children, and so you're not presenting well in family court. I think so. I actually, the judge in my case, the magistrate, I think he was a very nice man, and I think he tried his best. I really do. I don't believe that he intentionally treated me in any unfair way. I think he didn't recognize a lot of the things that I was trying to talk about as being concerning. Grooming, trauma, all of these things, he didn't see them the same way that I did. And when I first started in family court, I assumed everybody in that room knew more than I did. It never dawned on me that I was the only one who really understood the damage to my family and was focused on protecting my children.
Something you said and reminds me of something Lee said, and I've heard other women talk about, is that women are judged based on how they come across in court, and it's hard to even imagine what some of you have been through, and that you or worried you were going to go through, and you were protecting your children. Leah, you said earlier that you were actually you think, looking back, you might have been too nice, but do you think perhaps you were so, like, how do you, maybe if you would just shed some light on what Annie was saying, and just like how you think you might have not been taken seriously enough? Or
Well, one thing is that I also, before divorce was even a thought, I had to get an order for protection in 2000. The first time I had called 911, and he interfered with that call that I tried to make because I was so fearful. It just seemed like I was trying to be cooperative. And I knew that if I would try to fight him or look like I was fighting him in court, that he would say, see, she's not willing to cooperate, things like that. And I didn't want to be labeled as like a crazy ex-wife. Eventually I did become his ex-wife. But the bottom line is I was fearful. I wanted to protect my child, and looking back now, or our child, and looking back now, I wish I would have made a little bit more noise. The custody evaluator, I remember she called me when she was trying to determine custody. And, the custody evaluators, they don't know you from Adam. They spend a couple weeks with you, a month with you, whatever. They do one home visit with you, one home visit with the other parent. And I remember Michaela was actually being seen in a safety center at one point because he tampered with my vehicle, and he also violated the order for protection. So they arrested him, put him in jail. That happened like 3 or 4 times throughout Michaela's short life. But the custody evaluator called me, and she said, do you believe that Michaela's life is in danger? And I said, absolutely. I said, he's threatened to kill both of us. He's threatened to take her away from me, that she would be better off. She'll always be without a mom before she'll be without a dad. He threatened to kidnap her from me, take all of us out. And the custody evaluator asked me, she said, well, that abuse is against you. And I said, what? I said, that's a terroristic threat. And he's made it more than one time. And I actually had video where he was, or not video, but audio where he threatened to kill us. And my attorney at that time, she wasn't a divorce attorney, I found out later, but everybody minimized me, and the custody evaluator took her out of the safety center indefinitely because he wanted to take her to a family reunion, so she was not being protected. And I was a nervous wreck. Yeah, it was really bad.
And aren't there also cases, and Anna Estevez, I don't know if this came up in your case, but I know and mention if it did, and if not, I know you're familiar with this, where women are actually even disbelieved even more, and even prevented from bringing up allegations of sex abuse and other kinds of abuse. Like, it's almost like the more you bring to their attention, the matter the courts may get. Is that true in your experience, Anna?
So in my experience, it was a little different. So my ex-husband filed false allegations. And when Child Protective Services got involved, they could not substantiate what he said. But yet, for whatever reason, even though I provided evidence, documentation to them in writing, that my ex-husband had posted on one of the platforms that our judge ordered us to communicate on, they still dismissed it. And so when I brought up concerns that he was being physically abused by his father, he would come home with bruises. They basically told me that if I brought up another allegation that they would consider it emotional abuse at this point and would then take my child away from me and put him into foster care. So Child Protective Services threatened me and said that if another allegation comes up, that my son was going to be taken away.
Yeah, I should have said it's Child Protective Services where that's usually the problem often,
Yes.
right? Okay. Anybody else have any experience with that? That might be one of the most heartbreaking things of all that I've heard, where parents are feeling that, like, as things get worse, they can't bring these things to the courts and to Child Protective Services attention. Annie, tell us why you think the training bill that got passed in Maryland, and I guess it's taking effect. Is it in 23, or has it already started taking effect?
They're working on the training right now.
Okay.
So it'll be next year that it should be implemented.
I know some of the viewers are suggesting that training isn't quite enough, or isn't nearly enough.
Oh,
perhaps,
it is
but
not enough.
It's a place to start, right?
Exactly. There was a whole handful of bills in Maryland that we were trying to reform family court. It goes so much further than just training, but that's a start. The people that are making these huge decisions, the people that are literally deciding the future of a child, what their family will look like, what living for them will look like, their entire life is being decided in this room, theoretically by somebody who has no idea what domestic violence looks like, coercive control, what's the reporting process for child sexual abuse, how does those interviews look like? I mean, there's just so many things that are so relevant to these cases, and the idea that there's really no background provided to judges before they have to preside on these types of cases. So this is not the end all be all. It is a very small step. But
it would seem that it would make such a difference, though, because there is so much research in this area. I mean, I did a project on it 3 years ago, and there was so much new research.
Yeah.
I had
Even the
skeptical
idea
editors
that
saying, "What's the news?" I'm like, here. There's so
even
much.
just the understanding of childhood trauma
Yes.
and the adverse childhood experiences, even just understanding the impact of what this decision is going to do potentially to this child, maybe it'll slow somebody down and just get them to think a little bit more if they understand, here's what's at stake here. You're not even necessarily thinking, do I think this person is going to murder their child? There's so much beyond that. I mean, that's the worst case scenario, and it's horrifying how many times it's happened. There's also so many levels before that where it's just the emotional abuse or the constant abuse of the safe parent. There's so many different ways that children are being traumatized and treated like property in the family court system. I think it's so important that as these studies change and as research is changing and the information is getting better and better, why wouldn't we have the judges know it all?
But judges do, as Anna Estevez experienced, and we'll talk more about that. The judicial system in California opposed legislation in Peaky's honor. But Judge Vandenberg, why are judges opposed to more training, or like in your view? Like obviously you're not, but why do you think? Is it just that we're all busy? Is it that they say they're busy?
I actually don't know the answer. I know, it's very interesting. I think one thing about judges is they're so afraid of being called out or told they don't know something. And it's very dangerous. It's very, very dangerous. I've heard from judges, well, of course, nobody wants a child to get, like, we're all doing our best, and nobody does. I mean, we know that I wouldn't say we know that we're all doing our best, but I know I don't have a single colleague in the state of Michigan that wants to see a child injured. but what we know is that the family court system is failing families.
Mhm.
I think the other issue is that, again, I think it goes back to the fact that most people who are either appointed or run for judicial positions. So I'm a circuit court judge. I can hear felonies, and which are much, I don't want to use the term, I don't know, much more exciting, right? Or I don't mean exciting, it's not the right term, but much more prestigious, right? I might be on the news. The big civil litigation cases, I could hear a multi-million-dollar case. And so what happens is people, and a lot of people come in from prosecutors' offices with the goal of, put them in family initially, and they get out as soon as they have the next step. They have no desire to work in family law. So if they don't have any desire to preside over a family court long-term, why?
I get smarter about it.
Right. They
Good at it.
look at it as a temporary assignment. And so I think one of the things that we can do is, I always say, know your judges, know who's running for judge, start getting people to run who actually understand these dynamics and who want to do this kind of work and want to gain the expertise. I'm always looking for trainings to go to. I'm in a group now on a resiliency group and on trauma, and it's a year-long project. It's all judges, actually. So that's hopefully that gives you some hope. Judges who are involved in the child welfare system. But I think the first step is to get people who want to do this type of work. Not just they want their foot in the door, they do their time in family court and they get out. Because I'm thrilled if you want to send me to training. The more the better, because this is my area of expertise, I wouldn't even say, I don't even consider myself an expert. This is the area where I want to have my expertise.
Mm-hmm.
So I hope.
Let's anybody jump in here. I don't want to just, you're welcome to just kind of chime in when you feel on like this next couple of questions. So one that's of great interest is I personally have always found it interesting, sad and heartbreaking on some level, but even children who are abused by parents still want to be with those parents. And I don't know if that's one of the reasons, but like there seems that the importance of a parent, whoever the parent is, be they a rapist, an alleged rapist or a convicted rapist for that matter, whatever their flaws are, abuse and all this, the quote unquote right, need, importance of them seeing their child seems to weigh more heavily on the court than the risk to the child. Does anybody want to chime in on why they think that is and what can possibly be done? Lee?
Could I say something?
Please.
Yeah. I just assumed when I entered family court that they were going to err on the side of caution. And I mean, it should be a no-brainer that children are protected, and that if the abusive parent has a past history of abusing the protective parent, it just seems like safety should be the most important factor in deciding child custody in a family court case. Especially when you do have proof. I mean, I think that they need to look at the evidence. I mean, I was told for 5 years, all of Michaela's life, to document things. And I did. And I had witnesses and police reports and everything. And family court, when you enter family court, they do not look at that. They do not take that into consideration at all. And that's what I wish would change.
Is that true everywhere? I knew that could happen. Is it?
I really feel like a big part of the viewpoint in family court that's distorted is I don't believe children are being looked at as separate human beings, like real people. They are being looked at as property of some sort. And so there's a reluctance to say, okay, Dad, you can't have access to your children, your property, regardless of what your history is in that. I think that there's kind of this territorial type of attitude about the whole thing, where they're not given the same rights as humans should be given. They should have the right to not have a relationship with an unsafe person. And yet
I
somehow
agree.
the parental relationship is being treated as more important than the child's right to safety or security.
I agree.
Very quotable right there.
Yeah, so I'll jump in a little bit here. At least I can speak for Michigan. You know, and believe me, I'm not let's just talk about our statute itself. When I'm making a custody determination, one of the statutory best interest factors is domestic violence. So is there domestic violence in the household? So I consider that in every single case. One of the parenting factors is whether or not parenting time would cause a risk to actually the other parent and or the child, and what the in this case, what the risk of abuse and neglect is. So although there are 12 statutory factors and there are multiple parenting time factors, we do definitely incorporate that into the decision making. And now there is this, you know, it does say unless there would be, you know, harm to the child that they should have, but again, if they should have parenting time with a parent. However, again, if there is going to be harm to the child, parenting time can be stopped. So, you know, we, at least in our state, we have the tools, and frankly, it's my belief that in most states, domestic violence is a factor in child custody from the statutory perspective. I don't know why some of my, when I say colleagues, I don't mean on my direct bench, I mean throughout the whole United States. Let's talk about judges. Why they are not in, you know, certainly in these cases here, right? Using the tools they have to protect children.
How did
I
this?
think it's uncomfortable to look at. I think really what it boils down to is people don't like the idea of child abuse, especially child sexual abuse. And really, I think most people would rather connect the dots in any way other than someone has hurt their child or someone is going to hurt their child. And so I would bet that most states do have some sort of statutes that could be followed and could help protect if you were to believe the abuse and you were to look at it. But it's so uncomfortable that people just skirt over it completely. I mean, not just the judges, it's, and again, not all judges, but it's not just that role, it's the custody evaluators, it's your own attorneys. My own attorney trying to calm me one day early on told me that I really didn't have anything to worry about because it was, studies showed that people who abused a child sexually generally wouldn't do it to their own biological child.
Oh my God.
And that was the person that I was giving $50,000 to fight for me and my children. It's something that people don't like to look at. And so even though maybe the guidelines are there, I think it just makes people uncomfortable.
Right. And I will say that sometimes, I mean, you know, obviously as a judge, we are bound by the rules of evidence, we're bound by the evidentiary standards. And, you know, I could ignore them, but they will go up to the higher court and get reversed. So it's important that we have the evidence there. And I think sometimes these cases are difficult to prove. And that is one of the hurdles for judges and for parents, especially, and I'm not saying that we, you know, or I or others don't believe parents, but, you know, if you have, you know, 4 CPS investigations and they say nothing, we, you know, there's nothing here, we've interviewed the child, you know, at that point, these cases can get really, really tough. I think that's why, again, the education piece is important, because what I look for, especially in domestic violence cases, is I look for patterns. Patterns are really important to me in evaluating cases, patterns of coercive control, lethality factors. I'm looking at the whole relationship, not one incident. Not to say one incident isn't enough, but really looking at the whole dynamic in the family. I think a lot of judges are pretty uncomfortable with that. Honestly, I don't think they have the skills to kind of do it. And I have the skills, and it's not easy still. So I pray I'm getting it right. But
how about for the other panelists, if you could describe what your child was like, but also what your child was like when they saw their parent. Did you see a change? Was it a gradual thing where they did want to see the other parent, but then were afraid to, or were they asking to? Anna Estefes?
What initially when my ex-husband and I first split up, I think my son looked forward to seeing his father. But as time passed, it became more and more obvious that when my son was with his father, he was being abused. And, going back to the previous conversation about, judges not wanting to touch abuse in court, there's also, I think, a common misconception that, abuse is physical, and it's what I can see. If the child doesn't have a broken arm or a bruise, they're not being abused, when in fact, a big factor, especially with my son, was the emotional abuse. Every time, I would pick him up after him spending time with his father, it would take time for him to reacclimate. He didn't want to talk about anything that happened with his father. He was in a bad mood when I would pick him up, and it would take time for him to kind of, get used to the idea that he's safe and he doesn't have to, be on guard, and he doesn't have to worry about, being yelled at or being hit when he's with his mom. My son, one time asked me a question out of the blue. He asked me, Mama, are you going to get married again? And I was obviously trying to get rid of one husband, and I definitely wasn't looking for another. But that question blindsided me, and it concerned me. And so I answered, and I said, no, honey. I said, why do you ask? And he told me, he said, Daddy told me that you were going to get married again and you wouldn't want me anymore. And of course, that took my breath away. And I told him, I said, honey, I said, that Mama and Daddy love you, right? And he hesitantly said, yes. And then I said, Mama loves you with all of her heart, right? And he said, yes, Mama, I know. And then I said, that Daddy loves you, right? And his response was, no, but I love him. And so children, I think, inherently love unconditionally, even when they are abused. And my son, as much as he struggled with, having to go with his father, he knew that, I think he knew that there was nothing I could do about it, because family court tied my hands. When I found my son hiding behind the bed in a fetal position, telling me, Mama, I don't want to go. Please don't make me go. I mean, how do you prove that in court? What do you say to a judge? There's no way to prove emotional abuse, unless it's documented. And in my case, when my son was interviewed by the forensic psychologist who told Child Protective Services in writing that she believed my son was being coached, and I submitted that report to the judge, he disregarded it. I don't know what he did. I don't even know if he looked at it, because in that report, it not only contained, the fact that the forensic psychologist said that she believed he was being coached, but also the mental health consultant who said that when asked about wanting to be with his dad, he said, I don't want to talk about that. Clearly, there's something going on there, but when a judge ignores that and doesn't even bring it up when we're trying to prove that there is emotional abuse and even physical abuse going on, that's a problem. When they completely ignore evidence that's provided from what we call the experts, right? A forensic psychologist. Why would a judge not believe what that person is saying?
Right, who knows? Any Lee or Annie, any thoughts from the changes you saw in your children? Was there a desire to see the other parent, and then a resistance? Or we'll go to the next question.
My younger two daughters, they did early on want a relationship with their father. I mean, my littlest, she was 2 at the time that we got divorced, and my middle daughter was 8. And for a long time, I did prioritize maintaining a relationship the best that I could. I supervised visits myself, and we would have phone calls constantly, and his pictures were even still up around the house, because for a long period of time, it seemed as though his complete disappearance would be very sad for them. As time went on, it became evident that their contact with him was not healthy or good for them. There started to be a lot of sleep problems, a lot of behavioral issues, just a lot of concerns. And eventually my middle daughter refused to go see him anymore.
Mhm. Lee, you can comment on that, or you could talk about.
Well, I actually, in hearing Anna speak and Annie, I'm shaking my head, because that is exactly what it was like with Michaela when she'd come home from being with her dad, and initially I was very accommodating because I almost felt sorry for him. And I wanted her to have a relationship with him. And before, the custody stuff came into play, he was seeing her a couple times a week, and I would bring her over there, and there was a third party, that kind of supervised the exchanges and stuff like that. Because of the order for protection, he wasn't supposed to be near me unless he was picking Michaela up or dropping her off from parenting time. But as Anna said, it's almost like I didn't recognize her when she came home, because she was so naughty, but I knew why she was, because she could not express herself with her dad because she was afraid of him. And as she got older, when you had made a comment, Anna, about getting married, that Michaela said the same thing to me. She said, Mommy, are you going to get married again? And I said, why do you ask me that? And she said, because Dad said that if you get a boyfriend and get married, you won't love me anymore. And another thing that he filled her head with, on one of the times that I picked her up from a weekend visitation with him, and I was giving her a bath, and she loved bath time, and we were talking and we were singing and having a good time. And then she got really serious and quiet. And I said, what's the matter, honey? What's wrong? You can tell Mama. And she said, after a while of me asking her, she said, are you going to die? And she said it really quietly. And I said, why would you think that? And she said, because Daddy said you were. And I had to reassure her that I was going to be around for a long time. But that was his way of letting me know that he was not going to leave me alone. He was losing control over me. I mean, we had been divorced for 2 years. 50-50 custody was what the judge decided, despite, the domestic abuse and the stalking behavior, everything. And because parental rights, it seems that they prioritize that in Minnesota over the safety of children. And I know, like the ladies have said, John never hit me. He prevented me from getting up when Michaela would cry. He'd prevent me, he'd pin me down on the bed so I couldn't comfort her because she was crying or screaming, and lost track of what I was going to say. Sorry. Michaela's therapist, I had even told her about the threats and where she had asked me if I was going to die. And her therapist told her that, or told me that he knows just how to push your buttons, but he doesn't cross the line. And I thought, you know, you're a mandated reporter. And Michaela got to the point probably about a month and a half before she was murdered by him. She did not even want me to leave the room when she was seeing her therapist, and she wanted to be on my lap, and she was just getting very clingy, and I could tell that things were escalating. So there's so many similarities where they start using your children. And, you know, I didn't have bruises and black eyes. I didn't have any of that, but I had the threats to kill me. And she was in a safety center for a while because of what John had done in my vehicle, and he violated the order for protection. But like, you know, the ladies were saying, I mean, they get out or they're given another chance to hurt the children, you know, and that's what's happening.
So there are, you know, both horrifying similarities and horrifying differences in some of you ladies and other survivors' cases, but there are solutions that would help in all cases. And we've talked about training. Anna, if you could just talk about just what happened to the legislation in California and what those, it would have mandated training. And then I believe there were 3 other main provisions. If you could talk about those, and then let's talk about solutions to this. We do have some more time, but like, this is, you know, it's a system clearly in need of fixing.
So yes, thank you, Jane. So last legislative cycle, Senator Susan Rubio introduced Senate Bill 616, named after my son. It was called Peaky's Law. And initially it contained 4 provisions. The first provision had a mandatory training component for judges. Excuse me. It had language on what qualifies an expert witness in court. It had another provision that allowed for the introduction of evidence from previous abuse cases or restraining orders or violent behavior. And the 4th provision talked about prohibiting judges from ordering children into reunification camps. And so from the very beginning, there was collaboration with various stakeholders, including the Judicial Council here in California. And so right off the bat, the Judicial Council provided feedback, quote unquote. And as a result, we amended the language to eliminate the reference to expert witness and allowing evidence in family court. And so we moved forward with the bill, and the bill focused on mandatory judicial training and prohibiting judges from ordering reunification camps for children. And so I believe the Judicial Council did not think that our bill was going to get as much support and as much press time as it did. There were many supporters, and it picked up a lot of momentum. And so when I was asked to go to Sacramento to testify before the Assembly Judiciary, it passed through the judiciary without a problem. In fact, we had 2 Assembly members who wanted to co-author the bill because they believed so strongly in it. And so from there, it went on to the Assembly floor, and it flew through the Assembly with flying colors. And I think that's where the Judicial Council thought it was going to get held up, and it didn't. And so the very next day after it passed the Assembly floor, the Judicial Council issued their official letter of opposition. And they lobbied heavily against the bill, mostly ironically, not ironically, I guess, the part that they opposed mostly was the mandatory judicial training. They really didn't speak a whole lot about the reunification camps, which is surprising, but they were definitely opposed to the judicial training. They claimed that they offer a robust, and that was their word, a robust training program for judges. And they listed several different types of training and hours dedicated for each type of training. And of course, family court had the least number of hours. I think it was a total of 30 hours in just period for judges in family court. And so as a result, at the 11th hour, the Judicial Council tried to pull a fast one, and literally our Senate Judiciary hearing was scheduled for 3 o'clock. At 1:15, I was asked to go into chambers with the Senate Judiciary chair to discuss potential amendments to the bill. And so basically what I was told is that if the amendments weren't accepted, they would not hear the bill during the hearing. And so the bill essentially, or the amendments essentially said that the Judicial Council would be responsible. They agree to establish the training. However, if funding was allocated, and we all know what that means, if funding was allocated, then judges would have the opportunity to complete the training. So basically they agreed to develop the training, but they under no circumstances wanted it to be mandatory. And so after the hearing, Senator Rubio and I debriefed along with her staff, and it was agreed that we would not move forward because it compromised what we strongly believed in. And so we pulled the bill from going forward to the Senate floor. And so it basically killed the bill there. Good news is we started the new legislative cycle, and we've already drafted language for Peaky's Law version 2. And it will soon be introduced in the next few weeks. So we're looking forward to that. And the new version will contain all 4 provisions that we initially had. So we're fighting for those provisions, and we're aligning it with Caden's Law, which is federal law. And
if you could just explain for the audience, which is a big one, if you could summarize Caden's Law so everyone is sure, we're sure they understand.
Sure. So Caden's Law is a law that passed back in March. President Biden signed Caden's Law, and basically it contains the 4 provisions that I talked about in Peaky's Law, but it is federal law as opposed to state law. So what we're trying to do here in California would apply to the state and would align with federal law.
Okay, great. Ladies, anybody jump in on what you think are the most important of these or any other changes that you think would make the biggest difference? What would have made the biggest difference, perhaps in your case? Annie?
In my opinion, everyone that I dealt with, they did not have a clue what domestic abuse or domestic violence was. My attorney, and that's another thing too. A lot of parents that stay home with their kids, they don't have an income. So when I was served divorce papers, I was granted like a Southern Minnesota Regional Legal Services, SMERLS, for people that, don't have the money to pay for their own attorney. So she was court appointed, and she would tell me things like, don't push his buttons. All different things that were it's almost like she was working for my ex, or, my husband at the time. I just felt like my concerns were minimized. And I think it should be mandatory that anyone that's deciding the well-being, the best interest of a child or children, they have training and have a lot of knowledge about coercive control, domestic abuse, domestic violence. I found out actually probably a month before my divorce. I settled in a pre-settlement conference, and I was trying to get a different attorney. And I was told that she was a Social Security attorney. So she knew nothing about our situation. So I think that they should definitely have, there should be mandatory training. And I feel that there's no oversight. And that's a sad fact. I think that if they would be held accountable for their poor judgment and decision-making, I mean, if a child is murdered because of a court decision, I think that there should be some type of accountability. In my opinion, it's a crime. I mean, you know, John ultimately took Michaela's life, but he had help for almost 4 years. You know, that's how I feel.
And I completely agree. You know, here in California, after my son was murdered, we did file a lawsuit against the judge and the court evaluator and the DCFS, or Child Protective Services social workers, and even one of the supervisors. And the case was dismissed because of judicial immunity. And I agree. I totally agree. I think that if there was some level of accountability, that judges would take more time and would be more careful with reviewing evidence and truly evaluating what can be used as evidence versus what someone says. I think the outcomes would definitely be different if they knew that they could be held accountable for the poor decisions that they make.
But you can, how about your case against DCFS? Did that get dismissed as well?
Yes.
But didn't Susan Spell in California, she was successful in suing Child Protective Services, wasn't she?
There's been a few cases here in California that have been successful.
It's a good chance to we'll get back to Annie and the judge, but the judge, there's several questions for you, and one person was asking about Child Protective Services, and they were particularly interested in how they in their words, CPS basically stands down when they know that there's a custody case going on. Are you familiar with this practice?
Yeah, so well, there's a couple different things. So there is, if there's so we have two systems, right? So it's a little technical. So I don't want to take up a lot of time with it, just because we have the child custody system and we have child welfare, right? They are two different systems with two different, in terms of, I should say, there are two different statutory standards. So at the point that, for example, there is a petition for alleging abuse and neglect by Child Protective Services. Often if the child is placed with a non-respondent parent, so the custody is given to the parent where there's no allegation of child abuse against them, a lot of times they close that child welfare case. So that's one way that they work together. Sometimes if there's depending on the level of what the allegations are, if there's a safety plan put in place and the child is again put with the parent, where there are no allegations, who is not alleged to have committed the abuse, then CPS Child Protective Services will back out of the case at that point. So I don't know if that's, and kind of let the custody case go forward, because there's no imminent risk to the child. Well, the child's in with the parent who hasn't, there's been no allegations of abuse, and then they let the judge kind of figure it out. So I don't know if that's what the participant is referring to. Certainly, in my court and custody cases, I've had Child Protective Service workers in custody cases come in and testify to try to evaluate the abuse, so we can have an idea of what, the alleged abuse, to see what's going on, to see if it is safe for that child to have parenting time with the alleged perpetrator, if the abuse has been substantiated, other than supervised, or even maybe, there are cases where supervised is not safe. So let's be clear that, sometimes there are cases where there should be no contact, but it's all case by case. So I don't know if that answers the question.
Yeah, I think
follow-up.
Any Lindsay or Annie, you want to talk about CPS or that aspect of your case, or we have a million other questions, several in the queue, and I have a few more to go, but I do want to talk about, and also solutions. Anything about solutions is important to keep hammering on.
Can I just say, sorry, go ahead, Annie, you go first.
No, it's, I
Let me
was
just say I was just going to say about solutions is we need more professionals who are willing to get involved. That's the only thing I wanted to say. I'm sorry, Annie, and I'll let you.
no, you're fine. You're fine.
Therapists don't want to testify. I mean, it's hard to get the information sometimes. It's really frustrating. So I'm sorry, go ahead.
That's okay. For my family court case, CPS wasn't really involved for most of it. CPS was involved earlier on in the criminal court situation. They, deemed the children to be safe, but they were residing with me, and nobody even cared what the CPS report said by the time we got to the family court phase of things, because he was already convicted. So, I mean, we weren't talking about allegations. There wasn't an interpretation of information. It was pretty cut and dry. And it makes me so afraid for all of the families where it is in the allegation phase. It's not able to be shown or documented, because if a conviction of abuse against a child still somehow gives you rights to that child,
that's not enough.
That's kind of horrifying as far as I'm concerned. And one of the things that I struggled with the most is the burdens that were put on me, as far as he committed a crime. He pled guilty to committing that crime, and I am losing my rights to take care of my children how I think they need to be taken care of. And I think in a situation where there is a documented history of abuse, it should be up to the abuser to petition the courts themselves and, plead their case. At this point, we assume you are not safe to be around this child. You prove us otherwise, instead of this whole, let's all be nice to each other and let's sit and have holidays together. And it's just insanity to me.
Let's make sure, if we can come back for just a moment about your case, Anna, against you suing your judge. Is it impossible? There are a few questions about what you can do. Can you? Is there any way to? Can you sue a judge? I mean, judges do.
No,
you can't. I mean, you
they
can vote them out, right?
Immunity. They have immunity at this point. So when we talk about changing the system, that's definitely something that I would say needs to change. I think we need to take, because this topic is such a sensitive issue with so many people, and like we said earlier, nobody wants to touch it. I think, unfortunately, we have to take baby steps, and it's only by taking baby steps will we get laws passed. If we, even mention judicial, getting rid of judicial immunity at this point, they'll shut us down right off. They'll laugh us right out of the room. They won't even, touch us. So, it's unfortunate, because children will continue to suffer. They will continue to be abused until the system is overhauled. And that is so heartbreaking for me to say, because, my only child was murdered because of a failed system. And this is why I do what I do. Nothing that I do will benefit me or any children that I have, because my only child was lost. But, if what we do will protect other children, then it's all worth it. We have to. We have to be a voice for children whose voices are muted or aren't heard.
If we can talk about the training that would be, or that now is required in Maryland and that will be in other states, presumably soon, who will be doing it? Will folks like yourselves be able to be involved in it, or like who are the truly neutral people out there in this world? Anybody?
That's an excellent question.
Yeah.
Part of the Judicial Council's requirement was that they would develop the training. So right off the bat, we know that, or, I think the training will come from a certain perspective. I don't know how neutral or unbiased it'll be if they're the ones who are opposing it and they're the ones who are designing the training. to me, that just makes absolutely no sense. But in terms of who will actually deliver the training, we don't know that yet.
And also it's training too. It reminds me of, as someone who covered the federal government her whole career. I mean, like, there's guidelines, industry guidelines, but then there's laws and regulations, and it makes a big difference. I don't want to go off on too much on this, but there are certainly in criminal court, there are sentencing guidelines. Is it possible, or is this too much to even conjure with, that there could be some sort of something? Well, I guess sentencing guidelines but they aren't judges required to stick with sentencing guidelines?
Sure, but they're guidelines.
But
right?
that's what I was just going to say, as I'm saying the words, like, obviously
and we do have statutory frameworks to make decisions. I mean, one of the things inherent, in family law cases, one of the things that is incredibly difficult is it's so fact driven, and often, in many cases, you have two parties and not much other information, and that can be really difficult. As I was going to mention, I have this issue, treating therapists. They have people sign contracts all the time that say, I won't testify in court. They don't want to get involved. People don't want to get involved in the family court system. And I always say, well, that doesn't help me, because I have to make decisions based on evidence. And sure, I mean, I could just say, well, I have to have the evidence. Otherwise, it's not going to stick. It's, what I mean? It's going to go up and it's going to be overturned. I mean, there's a framework. But when other professionals out and about, doctors, teachers, and this isn't everybody, but, therapists, neighbors who have seen a child or witnessed something, don't want to come in and testify, that also, that makes it more difficult as well. I'm happy to take plenty of responsibility for our shortcomings, because there are many as judges. I'm not, but it would help if globally people were willing to come in and help us with some information. And again, this whole idea of bias, unequal. The only place I need to be unequal in domestic violence is in deciding whether it happened. I can't just, when I mean that is, like, two parties come in, I can't say, ooh, that person looks a little funny, they must be a domestic abuser. That I can't do. But once I have the evidence, I don't have to, that doesn't, I don't have to say, well, but I still have to give this person the exact same shot. No, I just need the evidence. So that idea of, it's I don't know where judges get that about, I think some of this honestly comes down to gender, in terms of, we have to, I've heard this many times. We don't want, because, statistically, and not always, statistically, majority of perpetrators of domestic violence are men. It's a known fact. I'm not making it up. I'm not trying to be biased. That's what the statistics tell us. That's what our government tells us, the Justice Department stats. And people say, oh, well, you don't want to seem anti-man. I'm not anti-man. I'm anti-domestic violence. But, people pull that component into it. They pull that into have equal custody. Or if you don't believe in equal custody, it's against men. And they pull that gender component in there where it really shouldn't be, frankly. It's about whether domestic violence is occurring in the household. And if it is, that is not a safe situation for children.
Judge,
sorry, I went on a tangent. Sorry.
That's okay. I'm going to let you do one more quick tangent in answer to this question. One of our viewers, participants, Geraldine, asks if her group, Protective Parents Michigan, can in any way educate the state court administrative office on the issues with parental alienation theory and the gender bias that they perceive in Michigan courts, to educate judges.
Again, parental alienation is a debunked theory that was brought out. I mean, there's no science behind it. So I don't know why it persists, but it does. Certainly we can have more training of judges on it. Now, there's a difference between, sometimes we do see what we call parental alienation, but it's not a syndrome in that same way. I mean, that has typically been developed as a way to undercut survivor's story of domestic violence. And that science is there, and that's a debunked theory. But yes, it definitely persists. And I guess my response is, you can keep advocating for continuing legal education for judges. We don't have CLEs in Michigan. We're not required to do continuing legal education to stay on the bench. I just got back from a week-long training and out of state, but that's voluntary. And the other thing is, if we had mandated training, actually give judges a little more cover to block their dockets and not be in the courtroom and go to training. So people aren't saying, oh, are you going on a junket? So that would be a great thing to get passed.
Maria Calder asks, and I thought Annie and anyone else could jump in on this. What if the medical evidence that 7 doctors, therapists, ER pediatric doctors, social worker, RNs, and pediatricians all came to testify on behalf of her son and the testicular infections and UTIs he was being treated for? They testified as forensic expert witnesses, waived their fees. The judge heard all the evidence and still gave sole physical legal custody to the abuser. Any response, thoughts on that scenario?
This is what we're fighting to change. I mean, there's no way you hear that statement of that information and think that makes sense, that outcome in that case. I'm really sorry for what she's experienced, and it doesn't make sense, and it's not fair. And I know that we are so fortunate to be having a conversation right now with a judge who is super focused on the evidence and on being as fair as possible in these really, really tough cases. But there are situations where the evidence is just being ignored.
Yeah,
and I don't have an answer to that.
I'm so sorry.
Judge? Go ahead.
No, I was just going to say, I apologize that happened to you on behalf of my colleagues. That kind of evidence, I mean, yeah, and I know those cases happen. I saw them as a lawyer. I saw them as a lawyer and as an advocate, and had things like that happen to my own clients. So, which again was why I ran, but I'm so sorry. It's just really no excuse for that.
Just a reminder to everybody watching that the organizers will be making sure everyone's responded to, including the person who wants to get in touch with Anna Estevez and bring that law to his or her state. A question for anyone to jump in here. Is there anything we can do when minors counsel ignores all the evidence? Anything?
So, yeah, let me jump in a little bit at this point,
Okay.
just because, I heard, Lee had a terrible experience with her attorney, and I'm not here to bash attorneys or judges per se, but look, we have an ethical duty, right? You have an ethical duty to represent your client adequately, professionally, and competently. It is not a breach of ethics to take a family law case and not be 100% on family law, but it is a breach of the ethics to take a family law case and not make sure you get up to speed where you need to be to competently represent your client. So, it's okay to learn new things, but then you got to put in the work to get where you need to be. So, in cases where somebody feels that a lawyer is not meeting the standard of competence and due diligence, you can certainly file a grievance with your local attorney discipline board. Those are, those are grievable offenses. We also have the Judicial Tenure Commission in Michigan. I'm not saying it's a perfect system on either, in either circumstance. I'm not saying it's panacea. I'm certainly not naive, but it is there, and no attorney likes to get a call from the AGC or JTC, so, which is what they are in Michigan. So, you know, I mean, that is something, if there's not competent representation, you can certainly file a grievance, and then of course there's malpractice, but certainly that doesn't help a child who's in danger. But the AGC is might be a little bit quicker. The other thing is, if you have a receptive judge, you may raise the issue that you don't think that the child is being competently represented. One of the things I ask in child welfare cases is, have you met with your client? There's a window in child welfare. Also in custody cases, although it's less frequent in Michigan to have what we call a lawyer guardian ad litem for a child. I inquire into, you know, see your counsel can raise those issues, or you know, in Michigan, there's no right to counsel for a family law case. And so about 75% of my cases that I preside over, at least one party is self-represented, which is another incredible hurdle.
How many states do have right to counsel? I didn't know there were any.
I don't know that I don't believe there are any right to counsel states, but as
Like
practice,
like a public defender.
right, not like in a criminal case where,
Right.
no, there's no right to counsel, but there are states that will provide counsel that's just, they've taken on that policy, or localities where you can get counsel. We have a wonderful family law project, but you know, they have 3 lawyers. I mean, they can't take all the cases. They only can take a handful. So anyway, sorry, I don't want to take up a lot of your time, but that is one thing you can do.
I think I can actually answer this question, and it's sad but true. Somebody asked, what happens to judges whose decisions lead to a lethal outcome? Well, in the case of Lee and Anna, nothing, right? Your judges.
Nope, absolutely nothing. He left family court in January of 2017, moved to another courthouse here in California, and is back at Stanley Mosque, which is the courthouse in Los Angeles. But he's not in family law. He's doing civil cases. He's doing like real estate and, I don't know, labor issues. So yeah, I keep track of him, but no, he's not in family law anymore, but he's still on the bench.
Mm-hmm.
And unfortunately, every time he runs for re-election, he runs unopposed. So by default, he's re-elected.
Someone named Amber is asking about cases where there's no, as a survivor, she hasn't reported abuse, and there's no obvious signs of abuse. She's saying, how does someone, she's specifically asking about Michigan too, how does she present this information to family court? And I certainly know survivors who recorded things.
But your testimony in court is evidence. Now, granted, I realize that leaves the credibility decisions up to the judge, and that can be hard. Especially if you're an educated judge. Again, I don't, you know, people, if they've been a survivor and they have post-traumatic stress disorder, they may present in a way that if you're not educated, doesn't look credible. People have a flat affect. They tell you they have memory issues. These are all symptoms of people who have been subjected to trauma, but it also makes them sometimes not great witnesses. So, you know, you've got to be, as a judge, I think about those things, but if you don't have a judge, they might just think, oh, this person's not telling the truth. But your testimony is evidence. I think the most credible, like what's very, details are really important though, if you can remember them, keep a book, just because, you know, maybe bring in someone from your local domestic violence shelter who can talk about the fact that, you know, many cases go unreported, that, you know, the kind of, you know, the trait, you know, if you don't have a judge who's educated, have someone who can come in and educate the judge about things that are common in domestic violence, including no police reports, no physical evidence, you know, go through the various issues, you know, financial control, limiting access to family, you know, build your case that way and hopefully get someone from your local safe house to maybe come in and testify and educate the judge if they're not educated. But your testimony, your statements are evidence, and you should know that. So
And we just have one more minute, so I think we probably should just do a quick go around. If there's anything, just 15, 20 seconds a piece. If there's anything you'd like to say that you didn't get a chance to, I'll start with you, Lee.
Well, I am honored to be on this panel, and it really helps to talk to people who get it. Years ago, when I was going through my stuff, it wasn't talked about. So we've come a long way in that aspect, but we have a lot of work to do. So thank you for.
As you said earlier, it almost nothing's changed in 18 years in the court system.
That's disturbing, and that should be problematic to everyone that's listening.
Annie?
Obviously there's a long road to improving family court and fixing all of the deficiencies. And there's not one step or one perfect solution. There's a lot of different angles, a lot of areas that things aren't working. And I think it's really going to take a lot of consistent work with advocates coming together, people using their real life stories to kind of put some realism here. These are real families, real children, real problems that are happening. And, I hope we can just all keep working together and make some change.
Great. Thank you, Anna.
I want to thank everyone for taking the time to join us tonight. Knowing that there were 130 plus participants on our call gives me hope and tells me that there are many who are out there who are willing.
More than 300 signed up.
Who are willing to be the voice for our children. And so I thank everyone for your time. And I thank you, Jane, and the rest of the panelists for being so amazing. So thank you.
And finally, Judge.
Oh, first of all, I just want to say I'm so honored that you asked me to come. I think that my input is the least important in this room. I think the lived experiences of Anna, Lee, and Annie, and the incredible losses, there's nothing more important than hearing that. I just want to say I'm sorry. I'm sorry the system failed you. It continues to fail people, but I am heartened that there are people like you out there fighting. I just want to tell you I appreciate you all so much.
Thank you all. Have a nice evening.